Welcome back. Good morning. Be seated, please. Our next case this morning is M&I Regional Properties versus East Park Community Development. Would you like to reserve some time?
I would, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
Okay, you may proceed.
May it please the Court, Scott Glass on behalf of Appellant M&I Regional Properties. First, in light of the last two cases that you all had listened to, I just wanted to let you know that you're not going to hear any accusations of attorney impropriety or slipperiness. There's been some good creative lawyering on this case and nothing but professionalism from opposing counsel, and I appreciate that. Your Honors, this case turns on the interpretation of two things. First is language in an acknowledgement that my client's predecessor in interest, its parent bank, executed, and which contains certain waiver language. And we're asking to have the court perform a de novo review of that acknowledgement and see if, as the trial court ruled, it was intended to waive any and all challenges to any aspect or proceeding related to the 2008 special assessments, or if we...
Could I just ask, you don't dispute the debt?
Absolutely not.
Is your contention that they could only impose the lien and accelerate the debt on, I think it was lots 9 through 13, and not reallocate the Series B bonds to lots 1 through 8, I think it was? Is it the acceleration, or is it the reallocation, or is it both?
No, we don't contest the reallocation. Going into the case, before I became much more versed in special assessment law than I had ever hoped to be, I thought that may be problematic, but through the course of the case, we have acknowledged that, yes, they are fully entitled to reallocate the Special Assessment Series 2008B bonds to those other properties, lots 1 through 8, because they did in fact receive benefit, and to not reallocate would allow them to have a windfall.
And so you don't dispute their ability on the bonds that initially encumbered 9 through 13, their ability to accelerate and foreclose on that?
No, those clearly became delinquent.
So we're only talking about what happens to the outstanding sum on the outstanding assessments for lots 1 through 8, which you don't contest the amount, you contest the acceleration and, well, essentially the acceleration and subsequent foreclosure of those.
Yes.
Your view, is it your view that because those bonds weren't in default at the time that the payment on I'm getting confused between the A's and the B's, but the 9 through 13 bonds, because the other bonds weren't in default, that they should have given you an opportunity to pay those out over some period of time versus calling them due right on the spot?
I believe they had several options. When the developer failed to pay the 2008B interest assessment in May of 2010 on lots 9 through 13, the CDD had several options available to them. At that point, those lots assessments, which were Series B assessments, were clearly delinquent. And under 170.10 Florida statutes, there's provision to accelerate those and foreclose on them immediately. As I indicated, lots 1 through 8, of course, received benefit, so it was appropriate for the CDD to reapportion some of that Series B special assessment debt that had been solely on 9 to 13 and place it on 1 to 8. At that time, however, lots 1 through 8 were not delinquent in any way, shape, or form because they had not been assessed for the Bs to begin with, and as admitted by the CDD, the 2008 A assessments, which had originally been assessed against all 13 lots, were being collected on the tax bill and were not delinquent. So we did not have an objection to the reallocation in the resolution 2011-01. It was the portion of that resolution where, after reallocating and adopting an amended final assessment roll, which, if you look at the amended final assessment roll, still shows annual debt service for each of the now reallocated lots.
You can help me with this, because I thought that, I think on the B bonds, that there was an agreement between, there was an agreement that, you know, that that it would be paid because they were contributing a certain amount of money, and I don't remember exactly how much it was.
Roughly 2
And then when
million.
they sent the bill, they replied back and said, we're not paying anything, we're just not going to pay. And it was at that point that they initiated the process to have the B bonds transferred to all the property, right?
The assessments, yes, sir.
Right. And they did that because they were notified that the person that made the agreement to pay wasn't going to pay.
Correct.
And so at that point, they had every right to accelerate. You said they had every right to do the transfer, and you're saying that, well, they weren't delinquent when the person that was supposed to pay said they weren't going to pay.
They had the right to reallocate.
Right.
Now, the $2 million was never a debt to the CDD. They were not out the $2 million. They were out $7 million, which they had expended and which had been allocated. I believe $3 million of it was the 2008 B bonds. And they had every right to reallocate that. They never sent a bill for lots 1 through 8. They just immediately reallocated it. In the final amended special assessment roll, they show this is how much the 2008 B annual debt service is on lot 1, lot 2, lot 3. They never billed them for that. What they did instead was they adopted in that resolution a statement that the 2008 B bonds are now going to be due one payment instead of over a course of 6 years.
Well, they had a right
And
to do
that was done before your client signed the acknowledgement, right?
No. Our client signed the acknowledgement early on in the process, but
That was certainly done. That was certainly done before, I think, months before your client took the property, took title of the property, right?
I'm sorry?
Yeah, that was certainly done before your clients took title of the property, right?
It did. It was done in October of 2010. Our client took title in December.
And so when you knew when you took title of that property that they had done that, and they had
Yes.
declared everything delinquent.
Yes, and our contention is that they do not have the authority to do that under
Mr. Glass,
17.09.
Let me understand, though, first, as to when you took title,
Yes.
you don't dispute the fact that your position should be no better and no worse than M&I Bank's. You're some sort of an offshoot of M&I Bank, a holding.
Yes.
So M&I Bank's position, whatever their position is, you accept that you're in their boat, whatever it is, right?
Yes.
Okay. And let me just see if I understand. The 2008 B bonds, which were roughly $3 million, which were originally allocated only to 9 through 13.
Yes.
You don't contest the legality of the bonds themselves.
No.
You don't contest the debt. You don't contest their ability to say, okay, well, they haven't been paid as they were supposed to, so they have a right to reallocate. The only part that there's a dispute now on is, having now reallocated, could they accelerate, could they modify the bond agreement or the indenture or the notes or whatever to now accelerate it and call the debts due? Do you agree that they could have done that on lots 9 through 13?
No.
Because,
Well, I mean, they could have accelerated under 170.10 on those because they were delinquent.
right, those were delinquent.
Absolutely.
Okay, so
But
as to
changing
lots
the-
9 through 13, I think, I'm just trying
Yeah.
to start to parse down where we agree. You
Yes.
agree that under, even without any reallocation or new resolution or anything else, they had a right to accelerate on lots 9 through 13 because the payment that was due wasn't made?
Yes.
Okay. Having now then said, okay, the payment wasn't due, wasn't made, we're gonna reallocate and we're gonna put a little bit on each of these lots. Your position would be, well, maybe you can foreclose and accelerate what you've now allocated to 9 through 13, but you've got to give us a chance to pay what we owe on 1 through 8
Correct.
and can't call the entire thing due. I mean, isn't that really where
Yes.
the rubber meets the road? And what is what is your contention for the idea that they cannot do that under the terms of either the statute or the bond indenture or loan agreement, whatever they happen to have?
Well, as you know, Chapter 170 provides for special assessments, and CDDs are creatures of statute. They do not have home rule power to issue special assessments. They only have the power granted them under Chapter 190, including the power under Chapter 170 to institute, levy, and impose special assessments. Chapter 170 tells you exactly how you do that and how you collect them. And it tells you what your remedy is if they go into default. Section 170.09 says how you must collect the special assessments, and it says you shall only collect them what it says is the special assessments shall, which is mandatory by the legislature, be payable at the time and in the manner stipulated in the resolution providing for the improvement. The legislature didn't say a resolution. It didn't say any resolution. It used the definitive article the and referenced resolution providing for the improvement. In this case, Resolution 2011-01, where they changed the payment terms for not only lots 1 through 8, but purportedly for all of the non-delinquent 2008A bonds, which they sent an invoice for, none of which were delinquent, that could not be the resolution providing for the improvement because the $7 million worth of improvements had already been constructed. If you look at Resolution 2008-05, you'll see the specific language, and I can find that for you in a second, which references that this resolution provides for the improvements that were contemplated under Resolution 2008-02. The initial resolution which set forth, well, we're thinking about putting in some infrastructure. Here's a preliminary assessment roll. We're contemplating 30 annual installments to pay this $7 million. Then it gets to 2008-05, Section 2, and I'm sorry I don't have the reference right handy, says that the board decided it's in the best interest of the CDD to provide these improvements. Section 3 then authorizes and approves the improvements. Resolution 2008-05 is, as prescribed by the legislature, the resolution providing for the improvements. 170.09 says they shall be collected in the time and manner prescribed in that particular resolution. The legislature prescribes something be done one way, it can't be done other ways. When it's mandatory, shall.
Do the bond agreements here have an acceleration provision in them? So
I don't know. That really wasn't relevant to this aspect of the case.
Normally, if I go to the bank and I borrow money, it says, if you miss an installment and you're, delinquent for more than 30 days, we call the whole thing due.
The statute, 170.10, clearly provides, let me find that for your honor, that if and that is under tab D of our appendix. Yeah, upon the failure of any property owner to pay any annual installment due, or any part thereof, or any annual interest upon deferred payments, the governing authority shall cause to be brought the necessary legal proceedings to enforce payment. In the event of the default in the payment of any installment of an assessment, the whole assessment with interest and penalties thereon shall immediately become due.
Okay,
So the legislature has
statute.
provided for an acceleration.
Second question, is there, and if it's not relevant, I mean, tell me why it wouldn't be, is there any cross-default provision between the A bonds and the B bonds?
No, sir.
In other words, frequently, if a borrower goes to the bank and has series of loans, you
I understand.
There
There is no cross default either statutorily or in the
There'll be a loan agreement that says, there is a cross default on this and it's a default on that, or says that it's not.
If you look at section 170.08, and again, this is how they have to proceed because they don't have home rule special assessment power, you will see that it provides that a final assessment roll shall be filed with the governing authority. Such assessment shall stand confirmed and remain legal, valid, and binding first liens upon the property against which such assessments are made. If you look at the final amended adopted resolution, try this again in English, the amended final assessment resolution, you will see that they assessed separate 2008 A bonds, 2008 B bonds, on 13 different lots. So there's not just one lien here.
What did the A bonds, what was the security for the A bonds since they had initially there was no,
They have a lien against the property of equal dignity to the B bond. Just like
but none of it was allocated to the
the A bonds were allocated to all 13 parcels, Your Honor.
okay, it was the B bonds that were not allocated.
Correct.
Okay.
Correct.
What does this part of the agreement mean when it says, the mortgagee further agrees that it will not in any way contest the legality or the validity of the 2008 assessments or contest or challenge the future levy or imposition of the 2008 assessments or any of the proceedings to be conducted in connection therewith? What does that mean?
What it means, Your Honor, applying common rules of grammar, the doctrine of the last antecedent, which has been recognized by the courts of this state, is that the last clause there, and let me find that language, where it says, or any of the proceedings to be conducted in connection therewith, only applies to the future levy or imposition of the 2008 assessments. So in essence, we have agreed not to do three things. Not to challenge the legality or validity of the 2008 assessments, which we did not, and we still don't, and we recognize if we win, those assessments are still liens on our property. Second, we will not contest or challenge the future levy or imposition of the 2008 assessment. A month later, after the acknowledgement was signed, i.e. in the future, when they levied these, they were not challenged. Finally, the third thing is we can't make a procedural challenge when they're levied and imposed because there's no comma separating that last clause. If there were a comma, then under the rules of grammar, it would have applied to all of them.
It looks to me as though what you're saying in order to induce the execution of this agreement is that, and then the following paragraph as well says that, in the event that there's a foreclosure, deed in lieu of foreclosure or whatever, the mortgagee recognizes that its title to the mortgage property is subject to all unpaid 2008 assessments.
Which we do not contest.
All right, but it seems to me when you go back to the prior paragraph, what you're saying is that you're just waiving everything that they do in connection with the 2008 assessments and the levy and the imposition. And
What's not included in that paragraph is the ability to challenge invoicing and changes in payment terms that are
Well,
not
here's what
consistent.
happened on October 13th, tell me if I'm wrong, on October 13th, East Park sent EPB an invoice stating that it owned $7,217,968.75 for the Series A and Series B bonds, including semi-annual interest, and EPB failed to pay the invoice, causing the assessments to be in default. And the trial judge apparently thought that, that essentially you're stopped from, because of what you said in the agreement, from now coming back and contesting the subsequent resolutions and the fact that they, accelerated the payments and declared them in default. And that based on the terms and conditions of this agreement, you can't do that now.
That is what he said.
That was an inducement.
Because he read that language as waiving our ability to challenge anything, and it doesn't say that when read under the rules of grammar and legally recognized.
So you're saying that when the trial court interpreted this,
He interpreted it
that it was
correctly.
error. If we say that the trial court was correct in interpreting this, well, then you're simply out, right?
Yeah, I think that would be correct, Your Honor.
You've exhausted your time by 30 seconds. I'll still give you another minute, and I'll give you all extra time, extra minute and a half if you need.
Thank you, Your Honor.
Good morning.
Good morning. May it please the court, Your Honor, Kent Seyfried and co-counsel Darby Scott on behalf of East Park Community Development District.
Hey, Fred, let me see, I'm trying to approach this thing. They're not contesting the debt, they're not contesting the reallocation. And let's focus on the Series A bonds. What event caused the Series A bonds to be in default that would, and I think that based on what I've heard, they don't dispute that if in fact those bonds were in default, you can accelerate them. So help me understand what event causes the Series A bonds to be in default?
The event is when the EPV failed to pay in October of 2010, when they failed to pay what was due on the B bonds, the $4 million that was due after reallocation. Once the B bonds came in default, the A's are in default automatically because there's one single lien covering the bonds for all the property. And you got to understand, with these two series of bonds, $7 million was taken out for improvements on these 13 lots. There's no distinction between what the $4 million in B bond money was used for from improvements and the A bond money. So $7 million was allocated to the whole property, improvements were made. You can't distinguish, this money was for A bonds, the A bonds are secured by the roads, the B bonds are
Well,
secured by
apparently you
sewer.
could, because not all of the bond money attached liens the way you structured it initially. I guess it was the A bonds didn't initially attach liens to lots 1 through 8 or 1 through 9. So apparently you could figure out, or you did figure out, where to attach this. I'm not sure that that was really legal, but that's not here or there.
It's a little bit different than that, because what we did, Your Honor, we didn't distinguish between what B bonds were going to lots here, there. We didn't allocate lots 1 through 8 on the B bonds because we were anticipating a contribution of $2 million from the developer by his agreement. So all of the improvements that were planned for was $9 million worth of improvements. What happened at the end of the day is $7 million of improvements got put on 13 lots. The developer came in and said, we're not paying the $2 million.
And it was the breach of that agreement that triggered the subsequent resolutions.
Right, because at that point, lots 1 through 8 didn't have B-bond debt on it, but they received the benefit of the $7 million just like the lots 9 through 13. So the district had to reallocate to make those assessments legal before we could foreclose.
Does the default on one lot create a default on all the lots? There seemed to be some disagreement, and you just said there's one lien covering all 13 properties. Does that mean if the owner of lot 13 doesn't pay, that you can foreclose against the other 12 lots?
No, Your Honor. What I said is one lien, there's one lien for both the A series and B series for one lot. So if you default on lot 19 or lot 13, the A bonds and the B bonds on Lot 13 will be foreclosed, not the A bonds on Lot 13 or the B bonds on Lot 13, because you can't distinguish the amounts of money for the improvements on Lot 13. So that's what happened in this case. But more importantly, if you kind of back up and you look at the timeline here, because it's very important, the landowner in this case is East Park Village, or was. The bank was nowhere in sight until long after all these things occurred. And if you look at the acknowledgement, the mortgagee acknowledgement, it was signed in March of '08, a month before the assessment resolution, the initial assessment resolution in April was entered. Bank signed this waiver and said, we're not going to contest any of this. If we ever take the property, it's going to be subject to the assessments. A month later, the district adopted the assessments and put the initial payment schedule in. So at the time they signed this mortgagee acknowledgement, they didn't rely on any payment schedule whatsoever. After the resolution, then you have the developer saying, I'm not paying the $2 million, I'm done, belly up, I'm walking away from this. District reallocates in 2010. Following that,
What gives the district the authority to they're not arguing about the reallocation, it's just the, number one, it seems that the reallocation takes two separate debts and makes them one debt. They had this, but to me, they seem like they're two distinct debts, perhaps sharing of equal dignity the same security. So what gives you the authority, number one, to essentially conflate these two debts into one debt so that you can then accelerate the whole shooting match?
Yeah.
I understand how you can accelerate the B bonds because they were in default, but isn't that a separate debt? I mean, you could theoretically, I don't know if you had the same lender, these were probably private placement bonds.
yeah, and that's the problem, Your Honor, when you get into the different series of bonds. They're structured that way for different reasons. The B bonds had a shorter term, interest-only balloon payment in the 6 years. And when the developer develops a property, they sell it to a builder or whatever, those B bonds are normally paid off, and then the end user comes in and pays the A bonds over a long period of time to make it economically feasible. But when you get a default in the first 6 years and you got B and A on it, you got two equal bonds that coexist, and it places the bondholders at odds with one another. So if the developer pays the B bonds but not the A's, then it places the A bondholders in a superior position to the B bondholders, and according to their bond indenture and all, they agree that the security for both of their bonds is equal, the property. And if one of the bonds gets defaulted on, then necessarily, because there's a single lien on that property to secure all $7 million, both series of bonds, then they would pro rata share in any recovery of that. Otherwise, you wouldn't have these different series of bonds being issued.
So is there a cross-default provision in the bond agreement that clearly says, borrower, if you default on A, that it's also a default of B and vice versa?
No, there's not a cross default because you've got a single lien. And the lien...
But there's a completely different, one is the debt and one is the security. You can have co-equal liens, and you could, in theory, this paper could have been owned by two different people. It doesn't have to be owned by the same person. So you can separate the lien and the debt.
But in this case, Your Honor, there was one lien on the property that protected the A bonds and the B bonds. There wasn't a lien for the A bonds, and there wasn't a lien for the B bonds.
Did you declare a default on both the A bonds and the B bonds, or just on the B bonds?
I believe it was declared default at 10 days after October 13th, when the invoice was sent and the B bonds, as reallocated, wasn't paid. And at that point, the B bonds were in default, and then A bonds were in default as well.
Okay, then how were the A bonds in default at that point?
Because once we begin to foreclose on the B lien, on the lien on the property, that because of the B bonds being in default, you necessarily have to foreclose on the A lien because it's one lien. Because that one piece of property...
But that doesn't put the bond in default, does it? If you get your judgment, you could get your judgment for what was due on B, and they could be redeemed and pay that off, and you could still, the property owner could retain the property with the A bond still on it, right?
Well, I think theoretically you could do that, Your Honor, but the A bondholder would then have to come in and satisfy $400,000 of the B debt, and then it'll end up, to secure its collateral, and it'll end up with a property that's completely underwater.
Okay, but it would still have a bond that was not in default that it could pay off over the next 15 years if it chose to do so, right? In that scenario.
I imagine.
Wouldn't necessarily be upside down, it depends how much each bond is, right? And what the value of the property is. Theoretically, the B could be small enough that the property's not underwater, and the A owner could come in and pay it off and continue to have the benefit of a 15-year payout on the A bonds, right?
Theoretically, if it was structured that way, that where there were two liens, one securing the B bonds and the A, but that's the reason that it wasn't structured that way in this case, because you got competing bondholders that would not issue bonds if that's the potential outcome. I mean, you gotta remember, these bondholders, when they're issuing all this money for these projects, they want absolute security. They don't want a challenge like this ever to come up, and that's the whole purpose of the mortgagee
Let me
agreement.
ask you a question about the acknowledgement. Was there any evidence presented or any arguments made based on who drafted this document?
No, absolutely not, Your Honor. It was stipulated that they didn't contest the validity of it. In fact, M&I's corporate representative wasn't even aware of this acknowledgement until his deposition in 2011, long after.
No, I'm not talking about contesting the validity, I'm talking about for interpreting the document. There was no evidence, it was drafted by party A, and therefore any ambiguity should be found against them, or it was jointly prepared by both parties, so there is no presumption one way. That wasn't an argument that was made.
No,
right?
no, sir, it was not, Your Honor. And we believe the plain language of the mortgage special assessment acknowledgement is plain and clear. I mean, if you read the entire document, you can clearly see that, you know, before the district and the bondholders are going to issue these bonds, they want absolute protection from any challenge whatsoever. And
Where is that covered? I looked at C and D. Where is that covered in this agreement?
that would be in subsection 2C regarding the waiver, as well as in.
I'm sorry, I didn't hear you.
I'm sorry, subsection 2C, which
Okay,
is the waiver
is that the
provision.
part that says the mortgagee further agrees that it will not in any way contest the legality of the
Correct.
2008 assessments or contest or challenge the future levy or imposition of the 2008 assessments or any of the proceedings to be conducted in connection therewith?
That's right, Your Honor. That's one provision, and the other provision is subsection F, in order to induce the district to impose and levy the 2008 assessments and issue the Series 2008 bonds for the benefit of the mortgage property, the district has required and the mortgagor has requested that the mortgagee acknowledge, one, the statutory priority of the lien of the assessments, that if the mortgagee becomes fee simple owner of the mortgage property by judicial foreclosure, its title is subject to all 2008 assessments not previously paid, and that's important, not previously paid. And in this case, when they took the property in December.
And what about, okay, that's F, okay, and D says, if the mortgagee becomes the fee simple owner of the mortgage property, whether by judicial foreclosure, so on and so forth, the mortgagee recognizes that its title of the mortgage property is subject to all unpaid 2008 assessments.
That's in 2D, so it's basically repeated,
All right, so F is repeating what's in D.
essentially, but F specifically says assessments not previously paid. So it adds 3 more words more so than
Okay,
subsection.
but I think what the concern is, at least with the other two judges, is that, okay, they take it and then they have to pay it. But what about the acceleration? Because some were in default and some weren't.
Right, and that gets us to the point of timing, Your Honor, because in December.
I'm sorry, point of what?
Point of timing.
Timing. okay.
Timing, because in December of 2010, when M&I took the property, they were fully aware that $7 million of bonds had been assessed. EPV had been given 10, 13 days to pay it. EPV did not, and over a month later, M&I took title to the
That
property.
7
Well,
million.
but the issue to them wasn't, I mean, they were sort of in a position, I viewed their agreement more as a subordination agreement, that whatever interest they had in the property, they were subordinating to your first lien. And they're not contesting your first lien, they're just saying, you know, we understand that, you know, you're in line first, we just want the opportunity to pay it in accordance with what they view as the new payment, that the payment schedule ought to be. They're not saying we don't have to pay it, they're just saying we don't have to pay it all right now. Let me ask a question that relates to the statute, the acceleration statute. It says, council quoted earlier, 170.09, the special assessments shall be payable at the time and in the manner stipulated in the resolution providing for the improvement. What was the resolution here providing for the improvement? Was that 2008-05?
It was two. That was the initial resolution because it did the initial assessments, but in 2011-01, when they had to reallocate,
Okay, but by the 2011-01, the assessments had been done, the bonds had been paid. That was the only, what 2011 did was reallocate. It didn't have anything to do with issuing bonds for the improvement, did it?
it didn't have to do with issuing the bonds, but it had to do with assessing, making the special assessments and attaching them to different properties.
Well, it says the special assessments shall be payable at the time and in the manner stipulated in the resolution providing for the improvement.
And
So the resolution providing for the improvement, I mean, that horse was out of the barn when the 2011 comes up. The improvement's made in the ground, it's done, right? Bonds are issued. The only substantive thing that the 11 does is reallocate and accelerate.
well, it doesn't accelerate, it changes the payment schedule, Your Honor.
Right, well, the net
essence.
result is, you're saying, instead of the next 30 years to pay it, we want it next week.
But it also imposes assessments on properties not previously assessed, lots 1 through 8, because in the 2008 ordinance, lots 1 through 8 were not assessed any B debt, and thus they weren't liable for any B debt in 2008, and so that ordinance had to be changed in 2011, which would supplemented and amended the 2008,
You
and
know,
it provided for the same
I guess the
improvements.
problem that I'm having is, it's a rule of statutory construction that you give words their common meaning, and it says, they're payable in the manner stipulated in the resolution providing for the improvement. And while there is a resolution in 2011 reallocating the debt and changing the payment schedule, there's only one resolution providing for the improvement, and that's the 2008 one.
Right. Well, I disagree with that, Your Honor, because again, in the manner, if the manner provided for in 2008 was lots 9, 10, 11, and 12 pays B debts. That's the manner. Timing was different. In 2008, 2011, we had to change the manner in 2011 to make them legal by law, because in the Boca Raton case, all assessments have to be fair and reasonable and properly allocate debt to all properties that are benefited. So in 2011, we had to change the manner in which those assessments were made
Well, you
by
had to change,
reallocation.
I can appreciate why you had to change the allocation. I'm not so sure, at least as it relates to the A debt, that you had to, I mean, we haven't seen the bond agreement, so I don't know what those say, but I'm not so sure that you had to, under the statute, say, well, you can't pay this off over the next 30 years, you gotta pay it off 10 days from now. What was it that made you have to do that?
The facts and circumstances in this case, Your Honor, because the landowner, East Park Village, says, we're not paying anything. We don't care, we don't object, we don't care if it's 10 years, 50 years, or 80 years, we're not paying
I'm
anything.
assuming that your bondholders are interested primarily in the money, and they wouldn't care if Santa Claus gave them the money, as long as they get it in accordance with what their legal rights are. I mean, I guess the question to me is, can you come in after the fact? I mean, is this a court of equity, or is it just purely an issue of law? Can you come in after the fact and rewrite it so that it's all due next week, essentially?
In this case, Your Honor, yes, because the landowner, EPV, did not object. M&I and Bank was nowhere in the picture at this point. They come in after the fact, months after, and try to make this, serendipitous argument that we should have been allowed an opportunity, but the landowner himself, who has standing,
All they're saying is
wasn't there.
they've got the same rights to object that the landowner would have.
We disagree with that. They said they had the same rights as the bank. A mortgagee and a landowner are not one and the same. in this case.
Your argument is that they knew about all this when they came in, is that right? When was the second resolution passed that kind of put all this together and said that it's now all due and payable?
October 2010.
October 2010.
Landowner did not object.
When did they come into the picture, according to your argument?
Approximately 2 months later in December, when they took the property by judicial foreclosure.
Well, they had instituted the foreclosure proceedings way before that, so they were involved, right?
And they had a mortgage before you guys were in the picture, which is why you needed the subordination agreement.
That's exactly
So
right.
it's not like they're Johnny-come-latelys.
No, then they could have been paying it before, back in
Let me continue.
April 7th, 2010, when the landowner said, I'm not paying, the bank should have stepped in and paid, but they didn't.
Yeah, well, let me continue on. So 2 months later, after the resolutions were passed, they continue on with their foreclosure proceedings, which had been instituted before. So when they instituted the foreclosure proceedings and they actually came into this, they didn't know that you were going to seek this subsequent resolution to kind of accelerate everything, did they?
Yeah, they were aware of that, and when they took,
How were they aware of it?
by the testimony from their corporate representative, that they were aware of it.
Well,
What
when was
the district
that?
was doing, I believe. It was Mr. Gessner, that was in June of 11. But he acknowledged, too, at the time.
June of 2011?
Yeah,
The
his
resolutions had been passed at that time.
Yeah, but he testified that he was previously aware of the
But we wouldn't- I
reallocation.
mean, it seems to me if they were aware of all this and then jumped in anyway, that's a different story, and that's what I'm trying to button down here. So his testimony was they became aware of it when? Was that before they instituted the foreclosure action, before they?
I'm not specific of that, but his testimony was he did not become aware of the mortgage acknowledgement, the document that waives and stops them in this case, until it was shown to him at his deposition in June of 2011.
Well, how does that make them aware of the fact that, you're going to adopt this subsequent resolution and accelerate everything at the same time?
I don't know that it does make them aware of that, but what it shows is that the bank waived all of these rights long ago, and then they're coming in after the fact.
Okay, and they waived the rights by virtue of what provisions of that agreement? Are we talking about subsection C, D, or F, or all three?
Subsection F2, G, or subsection 2C and D. And that's important in this case because the trial judge found estoppel, that they were estopped when they took the property subject to the $7 million bill, and they didn't challenge that on appeal. There's nothing in their brief that raises the issue that estoppel, finding by the
Well, I think
judge.
what they're trying to argue is waiver, right?
Well, that was two different findings by the trial court. The trial
Right.
court found in subsection 1B of its order, they're stopped from challenging it because they took the property subject to previously unpaid assessments. Subsection 1A dealt with the waiver. So it's two distinct
Well, the
rulings. of the trial
estoppel
court.
was based upon the agreement that they entered into?
The estoppel was based on subsection F, that when you take
But it was
property.
based on the written agreement they entered into.
Correct, and their
Court
conduct.
could just as easily have said they waived their rights by virtue of that paragraph of the agreement, right?
The trial court said it
This
did
isn't
both
equitable
things.
estoppel.
The trial court said it did both things. They waived it and they were stopped.
Okay,
by their
but
conduct.
both coming out of the agreement, not out of some other principle of equity.
Correct.
Okay,
Come out
and
of
you're,
agreement
and you're
and
saying they did not raise you're saying they did not raise the estoppel issue in this appeal, they just raised the waiver, or is it vice versa?
No, that's exactly what I'm saying, Your Honor. And the law is very clear on that. Failure to raise an issue in an initial brief is an abandonment of that argument. And since they abandoned the estoppel challenge to the trial court's order, this court must affirm on that basis alone.
All right, counsel, you've exhausted the extra minute and a half I gave you.
Thank you, Your Honor.
Give you 1 minute. You want it?
Why don't you address his argument that you waived the estoppel provisions of the final judgment because you didn't properly raise them in these proceedings?
Your Honor, I addressed those in the reply brief. I think what you
Okay,
clearly
well, I don't know
have...
that you can raise an issue for the first time in the reply brief. I mean, we've got cases that say if you don't raise it in the initial brief.
No,
then you
I
don't-
didn't, I may have misspoke. I addressed their argument that they made in the answer brief as to why that argument was incorrect.
Okay.
We don't think, and we don't think any reasonable reading of the trial court's order finds any theory of estoppel. It was simply the court saying you are estopped based on this document from the things that you acknowledged,
You don't
which
think that
was
that constitutes a basis, a ruling?
not
based on-
of equitable estoppel. It was simply a waiver, which the court, which is very common, not only in Florida, but in many jurisdictions. Waiver and estoppel are two separate but very closely related
But
legal.
what if we say, in
Correct.
looking at this, that the elements of estoppel were met and satisfied?
Well, I would agree with you with respect to when we acknowledge that we recognize that a special assessment lien is superior. We are stopped from now claiming that it's not. We're
Well,
not
the trial
doing that.
court said you were stopped from basically contesting the fact that they had accelerated, and you have to pay everything now. Everything has to be paid now.
The trial court
And there
said-
are differences between waiver and estoppel. There are different elements.
They are.
And if we go through this record and say, well, the trial court was right, and estoppel, is appropriate, and you didn't raise it in your brief, then you've waived it, right?
Well, that's in the discretion of this court and in its reading of the initial brief. We argued in the reply brief that we did, in fact, address that in the context of the waiver, not perhaps with the use of the term estoppel.
You just confused waiver and estoppel.
Yes, Your Honor.
All right,
All right, and
counsel,
that-
thank you so
and-
much.
And based on that confusion, that allows you to raise it or requires that we take a look at it and say, well, your argument is essentially waiver, and we have to look and see, well, the trial court was essentially talking about waiver. If the trial court was talking about estoppel, then you didn't preserve it and you're out, right?
Well, it's in the discretion of this court to look at that, yes, Your Honor. Thank you all very much for your time.
Thank you both. Have a safe trip home. All right.